so much for joining us on a weekday. And we know that it is a weekday. We know there are time constraints. So we have planned like a crisp but a very content-filled session for all of you. So my name is Shweta Rath, but I'm logged in by the name of Bhavna Agarwal. I'm a senior associate at Lawsikho. And we have with us today Mr. Pranav Srivastava, who is a partner at Phoenix Legal and has extensive experience handling mergers and acquisition transactions. So the topic of today's session is actually quite broad. That is the role of corporate lawyer in M&A transactions. I think this is something that every second person wants to know, has a vague idea about. But what is the actual work that entails? What kind of M&A transactions do company get into? What kind of situation requires what particular transaction? And where do external lawyers have to step in? And what is the beginning and end of it all? Is something that people are still not quite aware of. And sad to say that we don't have extensive literature on it as well. The way we have, literature on the theory part of it, that okay, how to deal with the work, but what comes along with it is something that not many people are sensitized with. So this is exactly why we have invited Sir today to shed some light on it. And the way we'll go about with the session is that we are going to start with something very personal, as to we'll ask Sir as to why he started getting into corporate law. Why did he prefer corporate law over, let's say, a litigation field? Because this is, I think, the prime struggle that students face when they have to make a career decision after law school. That kya kare, litigation mein jaye ya law firms mein jaye. And I was myself in litigation and I have worked in a law firm as well. So I also wanted Sir to dispel some myths about law firms that students are enamored with when they are in law schools, which is why by the end of the session, we'll actually have Sir discuss some things as to what kind of people should not go for law firms instead of what kind of people should go for law firms. Because it's very important to know that, okay, what all you're not supposed to be looking at. These are the things you're looking for, then law firms are not for you. Or let's say M&A field is not for you. And primarily, we'll be dealing with what exactly entails mergers and acquisition transactions. When do external lawyers have to step in? How do the deals begin? What is the work that lawyers actually have to do in an M&A transaction? Because M&A transactions are not so specific like any other field, let's say competition or tax or banking. I think M&A transactions include all of it. So what is the work that entails? And we also have a lot of people who want to become in-house counsels in future. So if they want to become in-house counsels, a common query we face is that I do not have experience with M&A. I haven't worked with a law firm. Does that make me ineligible to become an in-house counsel if I have not worked with M&A transactions? And if I am to become an in-house counsel, what is it that I'm supposed to know when I prepare for an interview or something? So with this, Sir, let's begin with the session. Once again, thank you so much for sparing the time for this particular session.
No problem at all, Shweta. Thanks.
Yes, sir. So my first question actually would be, as I said, that what is it that made you choose corporate law over, let's say, a civil litigation field or a criminal litigation field?
So I think, I guess all of us go through that phase in our life as law students, when you are in second year, third year of law school, you're trying to figure out, I think, what you want to do, whether you want to be a litigator, you want to be a corporate lawyer. And I guess the earlier you are able to figure out, I think it easier it becomes for the next steps to be tailored accordingly. And fortunately for me, I think, the turning point was an internship with a corporate law firm. I was interning with JSA, their Gurgaon office, and I guess that was kind of the turning point where, and I guess the factors that any law student gets enamored with during those early years about corporate law as a profession. And same were the factors for me to get enamored by, I think, looking towards corporate law as a profession, whether it be fancy offices, big deals, huge numbers and stakes involved. Back then, not anymore, but by people on BlackBerry phones and all the late night work, ordering food from big restaurants. I think all of those were little, I guess, factors that enamored me initially towards corporate law as a profession. But I guess, of course, those are not the right reasons to choose the profession. The bigger push that I felt that for me, which drove me towards corporate law as a profession, as against a litigation, for example, is the extremely professional work culture. Unlike I think, I mean, of course, in India, in every field you see nepotism, you see a lot of things being driven by factors other than pure merit and hard work. Corporate law firms are to some extent, and I'm not saying to a great extent, but some corporate law firms, specifically firms, professional firms like where I belong, Phoenix and others, are very, very professionally driven, and they're driven by merit and they're driven by hard work. I think that was one factor that drove me towards corporate law. That if you work hard, I think the sky is the limit, and you don't need a grandfather senior advocate or a great grandfather senior advocate. And I did have a grandfather senior advocate, but I didn't rely on that. I didn't even choose litigation practice, and I went into corporate law practice. So I guess that work culture and that professional and a merit-based hard work being short path to success, I think those were the factors that drove me the most towards corporate law. I think the third and the most important factor why anybody should take this decision, these were the factors for me, but I guess for anybody to choose corporate law as a profession should be, and it was to some extent for me, is also whether you have any affinity towards corporate law and law subjects. Because if you don't have it, I think all professions take away part of your life. If you're becoming a corporate lawyer, it takes away all of it, and if you don't like it, then you're going to have a terrible life. And therefore it's extremely important that you like and enjoy corporate law, commercial law subjects, and not just subjects, but generally business overall, numbers, corporate deals and transactions, whether you enjoy what's happening in and around in the business environment. If you don't like all of that, then I guess corporate law is not the right field for you. You could look out for other areas where you develop interest. Corporate law is meant for, I think, people who have a passion and like a preference and affinity towards those kind of subjects, those kind of activities. And if you do, then I guess that should be the biggest reason for you to opt for corporate law. And I guess that has those three factors, I guess, in internship that I did with JSA, then coupled with the fact that I really liked the work culture, and third, I generally liked the subjects that you work on in corporate law as a profession, and because of those factors, I chose corporate law. Unfortunately for me, I think I made that decision very early in life. I was just in third year of law school when I decided I want to do corporate law. And since then, I think all my internships were corporate law internships. I was doing courses on corporate law. I was reading corporate law. I reduced my mooting. I used to be an avid mooter. I used to do a lot of mooting in law school. But since then, I think I kind of put that on a back burner and started focusing more on, I think, the corporate law side of things, whether it be even studying accounts, for example. I started studying and reading a little bit more of accounts and a little bit more of economics, just because I knew that that's where I have to be.
Absolutely. I think that is another thing that people should keep in mind, because we have a lot of lawyers who I think hesitate at the sight of accounts, tax or economics. And we try to explain to them that, listen, if you want to pursue corporate law, you can't pigeonhole yourself to one particular field of corporate law. You have to have that openness towards working in any area of corporate law, be it banking or let's say company law and then maritime, if it comes into your domain. So that, and I think when you said that it takes away a part of your life, and the second important thing you mentioned, that if you enjoy it, then it may not seem like it's taking away a part of your life, because you're enjoying the work that you're doing.
So I said, any profession takes away part of your life.
Yeah, anyway,
all of it. Corporate law will take away all of it. So
absolutely, even we are at Lawsikho, we're doing we are a startup right now, and it takes away a good part of our life. Everything we breathe today is about the startup. So I really can't say that, oh, nay, life could have been better or worse at trilegal. I mean, we're putting in the same number of hours at the end of the day. Only the nature of work differs.
Yeah, no, absolutely. Absolutely. And specifically as a lawyer, and I think specifically as a corporate lawyer, I think you have to be ready to put in the hard yard, because there is no alternative to that in this profession.
There is no alternative. Absolutely. I mean, it's a question that a lot of people ask us when we interview students, and they're saying, does it mean long hours? So we said that you cannot really, if you want to pursue corporate law, then you cannot have that as a concern, that, oh, long hours.
Yeah,
that will be synonymous to corporate law or any kind of law if you're specializing at the end of the day. The fact that you've chosen to become a lawyer itself means that you're going to be putting in long hours.
Yeah, absolutely.
So great, sir. So I guess we have a very good background and we have a good number of people joining us also. So if we could actually jump into the main topic and the heart of the session, and we can start with something very basic, just because we do have some people who may not be aware of what exactly are M&A transactions, mergers and acquisition transactions. So we can begin with what do you mean by mergers and acquisition transactions, and then go on to discuss the role of corporate lawyers in it and the life cycle of a deal.
Sure. So M&A, I think mergers and acquisition, as the name suggests, it comprises two parts, mergers and acquisitions. Mergers are typically, the court-driven exercise where two entities come together, join to form a third entity. And an acquisition is a transaction where one company takes over, acquires another company or that other company's business. So as the name suggests, merger is two people coming together, two entities coming together. An acquisition is one entity coming over the other and acquiring the other. Merger typically in India is a court-driven process. You have to approach a high court of the location where your registered office is located, and you have to apply for file a merger scheme, and through that ultimately achieve a merger, accomplish a merger. Acquisition is what, and typically more litigation lawyers tend to do that merger side of thing than corporate lawyers. While we may be working on the scheme, etc., ultimately it requires you to go to the court. What corporate lawyers more frequently do, and as M&A is understood in general parlance, is mostly acquisition transactions. And in addition to acquisition transactions, it also covers something called the joint ventures, where two parties come together, they set up another entity and start doing business together. It also companies within itself, the sell-off, the exits. It covers within itself asset transfers, slump sale transactions, where entities come and acquire the business of another entity. It may not involve acquisition of the entity itself, but the business gets acquired as assets, or it gets acquired as an undertaking, as a going concern. Running business gets transferred from one entity to the other. So those are different types of M&A transaction, and that's so. M&A basically means a merger and an acquisition, but typically in common parlance, what we corporate lawyers do is mostly the acquisition side of it, which includes acquisition as well as sell-offs, transfers, asset purchases, asset sell-offs, split. Mergers also include demergers. That's what I think M&A transactions comprise.
Absolutely. Guys, just like a common note to everyone, we'll entertain all the questions in the end. So I'll just request everyone to put their questions on the chat box. And once we're done with the segment, we'll take up all the questions one by one. Okay, so that we don't disturb the flow of the entire session. Okay, great. Now that we've actually understood what constitutes M&A transactions, and we've understood what are the different types of transactions, if so, you could shed some light on what are the factors that determines a client's choice to opt for, let's say, one transaction over the other. I mean, we know that acquisition and mergers are very different, but within that, let's say, when to go for a merger or an amalgamation or a spin-off, or let's say a split off. So how should a client arrive at that?
So typically, it depends on, I think, what the client's objective is. So if a client is looking to say, it already has an entity running, it does not want to take the risk of, say, liabilities which are currently under the other entity, or if that other entity has multiple businesses and client wishes to acquire only one business, it would not opt to acquire that entity as such, and will only opt for a business transfer to acquire the business of that entity. Now then tax factors will come in, whether that business transfer should be transfer of assets or should be a slump sale, which is a transfer as a going concern, because the tax implications in both are different. There is no GST on a slump sale transaction, there is GST on an asset purchase transaction. The income tax treatment is different. So depending on, I think, what the client objectives are, they would either choose an asset purchase or a slump sale in that situation, if they don't wish to acquire the entity. If they wish to acquire the entire entity, of course, the liability of that entity also comes along with it. If two entities want to come together and do a certain business, of course, acquisition is not an option for them. Joint venture is the option for them. In that situation, they would together come, pool in their resources, perhaps set up a third company in which all the resources will be pooled in, funds will be infused, technology will be transferred, assets may be transferred, and then they will start doing that business. So it depends on, I think, the client's commercial objective on whether they would opt for a acquisition, merger, demerger, sell-offs, exits, joint ventures, slump sale, asset purchase. I think it all depends on what the client's commercial objectives are. And of course, there are pros and cons of each of those methods of doing things coming from various laws, whether it be company law implications or it be tax implications. So there are pros and cons of each of those methods, but of course, it depends on the client's commercial objective, what they seek to achieve.
So, sir, I can see both two situations over here. I think one is at an advisory stage when a client is contemplating what transaction it should undergo, and the second stage where the client has taken a decision and then the role of a lawyer starts. So, at an advisory stage, do corporate lawyers play a part where they have to advise, no, instead of this transaction, go for this transaction?
Absolutely. So, a client would typically, I mean, so there are different stages at which a client could approach you. A client could approach you at a very early stage, and if you have a long-standing relationship with the client, they will reach out to you even before they are planning to come to India, and they will then take your advice from the very beginning. Or the client would, in most situations, the client would approach you at a stage where they have done at least a high-level heads of terms or a term sheet or a MOU, and at that stage, client would ask for various options. So should we set up an entity? Because even an acquisition can be done in multiple ways. You could acquire an entity as a foreign entity if it's a cross-border M&A.
Yeah.
Foreign entity will directly acquire an Indian entity, or a foreign entity may want to set up an entity in India to do some activities and also acquire another entity. Or if it's a slum sale, it will require a local entity to be established. So then if the clients would approach you at a stage where the first step of advising a client on an M&A transaction is typically the transaction structuring, where the role is played by, of course, corporate lawyers and tax lawyers and the financial accounts advisors who collectively advise the client on what transaction structure to adopt. Once that is finalized, I think we move to the next steps, which is, after execution of term sheet, there will be a due diligence which will start. There will be an exclusivity period in which I think nothing else will be, no other offer will be entertained by the seller, and they will hold the asset only for the proposed buyer or who's your client. There will be due diligence that you will conduct. Once the due diligence is completed, simultaneously or after that, you will start working on the transaction documents. You will be drafting the share purchase agreement if it's an acquisition of a company. You will be doing if it's part acquisition of shares, you may be doing a shareholders agreement, because then you have to also regulate the rights and obligations between the new shareholder and the existing shareholder. If you're acquiring a company from another group, for example, a X group company comes out and there are lots of services which were being provided to that company by other group entities, you could also be required to do a transitional services agreement. Because if, for example, an entity that you acquired didn't have an accounting function internal and accounting facility was being provided by another group entity, then you need that group entity to continue to provide those services. So you need a transitional services agreement. Once documents are finalized, you would execute them. There would be something called conditions precedent.
But the volume is going a little low. If I could just request you to just increase the volume a little. Yeah, sure. I know this is one of the prime questions that students had, that what is the life cycle of a deal, which we kind of jumped into. So yeah, so I think this is the part where they wanted to kind of make notes.
Sure, no, absolutely. I can repeat that if required. I think in terms of life cycle of a deal, as I mentioned, I think most frequently, typically, a corporate lawyer will be engaged at a stage when there is either a heads of terms or a non-binding term sheet executed, or it is about to be executed. Initial draft has been circulated. From there on, I think we would do a detailed term sheet, execute that. After execution of a term sheet, we will have a due diligence exercise. Typically, if you're acting for the sellers, then depending on whether you're acting for the seller or the buyer, if you're acting for the seller, then you're assisting in the due diligence. If you're acting for the buyer, then you are yourself undertaking the due diligence exercise. Financial advisors will undertake the financial due diligence side of things. You will undertake the legal side of things. And if you're also advising on tax, then you will also be doing the tax side of things.
Right.
As the due diligence is in progress, either parallelly or after completion of the due diligence, you will start work on the transaction documents.
Yeah.
Or in most cases, it would run parallelly. You would be working on the transaction documents. Transaction documents will also reflect the findings of the due diligence. So, for example, in due diligence, if you find out that there is a certain approval which was required is not in place, you may want to include a condition precedent in the transaction document saying that before the deal closing, you will obtain that approval. And until that happens, you're not going to complete the acquisition. Similarly, if there is a problem that has been discovered, a potential liability, you may want to incorporate a specific indemnity in the transaction document saying that if this liability arises, then you will indemnify me. or depending on what the counterparty is telling you during the due diligence, you may want to incorporate representations,
Right.
where or confirmations in simpler words. I think a confirmation or representation of facts you may want to include within the transaction document. So transaction documents and due diligence, most cases runs parallelly. Once you've completed the due diligence exercise, you finalize the transaction documents. There is the execution stage where
Right.
the transaction documents are executed by the parties. Once the transaction documents are executed, there are typically certain conditions precedent which are prescribed in the transaction documents, which may incorporate the approvals and permissions that you are required to obtain for closing the transaction. It may incorporate certain corporate corrections that you need to do. Various non-compliances were identified during due diligence, and those have to be corrected. Those may all be incorporated. If any contracts need to be novated, if any permissions need to be taken, so all that will be put in as activities that need to be completed as conditions precedent to the closing of the transaction. Once the conditions precedent are completed, parties will exchange something called a CP confirmation certificate or a CP fulfillment certificate that the conditions precedents have been fulfilled. Once that is done, you move to closing. Closing is the time when actually the transfer takes place. If it's a share acquisition, you're acquiring an entire entity, then that's the time when you will sign a share transfer form. The consideration will be transferred. Once the consideration is transferred, and share acquisition is completed, directors may need to change, various activities may need to take place on the closing date, and depending on whether it's a cross-border or a local M&A. If it's a cross-border, then you will need to do if there is a share transfer, you may need to do FCTRS formalities with the Reserve Bank of India. And after that activity, your closing takes place. Now, once the closing has happened, the transaction is complete. But the job of a lawyer and the job of the advisors is still not over. I think we have to also, depending on the type of the transaction, there could be conditions subsequent to closing where certain filings are required to be made. For example, if you change the directors, you will have to intimate the registrar of companies about the change in directors. Filings may be required with respect to, say, change in nominee shareholders, where you have to make the beneficial ownership filing with the registrar of companies. If it's a RBI transaction, you may want to get an acknowledgement of the FCTRS form that you filed. There would be various steps post completion of the closing which may need to be undertaken. In certain transactions, although in cross-border transactions it's quite restricted and there are limitations, but in certain M&A transactions you will also find provisions with respect to post-closing adjustments. And where, for example, if a party X agreed to purchase a company from party Y, and party Y said that this is my demand, party X said I don't agree, I think only this much is the value, and therefore the parties agree that, okay, if this company is going to achieve this much targets in the next year, then I'm going to make you an additional payment of this amount. That's called an earn-out. You could agree to an amount, and you have to continue to even work after the closing of the deal to give effect to those earn-out provisions. Similarly, there may be adjustment provisions. And adjustment provisions typically happen is because when you close the deal, you make certain assumptions with respect to what's the working capital in the company, what are the liabilities of the company, and on that date, it is not possible for auditors to immediately do an audit and figure out the exact number. So you take certain assumptions that, look, we expect the working capital to not exceed this amount, we expect the loans to not exceed this amount, etc. And after a few days, you will do that reconciliation, and if you discover that the liabilities were more or the working capital was less, you may want a payment to be paid back to you, and therefore an adjustment to take place from the seller, or vice versa. If there is an excess working capital or lower liability, the seller may want more payment to be. There could be those post-closing adjustments. And similarly, there could be indemnification payments. There will be a certain time period which is provided for different kinds of indemnity, different time periods. Tax indemnity may provide for a 8-year period. Other indemnities may provide for a 3-year period, during which any claims can come from parties. Where if a seller identifies a problem that was not disclosed during due diligence, which is contrary to a representation made, the buyer may make a claim for a breach of representation on the seller and may want to recover the damages. And therefore, that activity continues in certain transactions. In certain transactions, once you close, you close. So those broadly is the life cycle of a typical corporate acquisition transaction, and those steps will vary depending on if it's an asset purchase. The steps are completely different. I mean, then there is no transfer of shares, there is transfer of assets, and as we discussed earlier, it could be transfer of assets, or it could be a slump sale, transfer of a business as a going concern. So depending on the nature of the corporate M&A transaction, the steps would vary, but broadly these are the steps and the life cycle of a corporate transaction.
I think so. The point where people get confused quite often is the difference between execution and closing. Because why I say this is because I come from a background of competition law. And over there, when let's say a transaction has been commenced, CCI has this rule that before we give our blessing to the transaction, you cannot consummate any part of it. Okay, so the question becomes that okay, what would amount to acting upon the transaction? A lot of M&A lawyers have this saying that oh, we haven't closed it, so it's fine. But then CCI said that no, the moment even one of the conditions are acted upon, I would say that the transaction has been closed in some way or the other. So, does any exchange of consideration happen at the point of execution? If you were to draw a line between execution and closing, how would you define it to law students?
So execution is nothing but signing of an agreement to do something in the future, and
Right.
actual completion of transaction only takes place on the date of closing, which is consummation. Because there could be a lot of conditions precedent to closing which may not complete, in which case you will not complete the transaction. So for example, you enter into a contract for acquisition of, say, a company which requires the consent from the regulator for the company to be transferred,
Right.
and you've built a condition precedent that that approval will be taken, and I can't close. Or when Shweta, the example that you were giving with respect to competition, if it requires a CCI filing and an approval for the transaction, and basically if it is above the thresholds which are prescribed under the Competition Act and the de minimis thresholds that they have come out with, if it is above that, then you may want to put a condition that the approval from CCI will be obtained, and only after that I will close the transaction. And therefore, everything if the transaction comes into effect only on the closing. Signing is nothing but execution of an agreement to complete the transaction on a future date. In several of the transactions where I think competition is not an issue because of lower the threshold.
Yeah, thresholds are not being met.
Yeah, and where in simpler transactions, parties also sometimes fight for the same execution and closing date, and they say, look, we don't want a gap between the two. Everything that needs to be done should be done in advance, and the day we sign, the day we close. So it could also be simultaneous, but in most transactions, you would find a gap between the date of signing and the date of closing, and the transactions can fall through.
Yeah, actually, I've come across transactions where the execution and the closing date happens to be the same. I've really not seen any kind of such transactions.
It happens, and we've seen it, I think, in very complex transactions as well. I mean, lots of clients are skeptical about signing documents. When nothing is going to, it's not certain whether it will close or not, and they say that look, whatever was required to be done as conditions precedent, we will just do it even before we sign. I mean,
But so in that case, if you require permissions from other regulatory bodies like SEBI and CCI, and there's a mandate that you have to produce the transaction documents over there. So if they've not been signed, if we're speaking about a situation like this, then what do you actually submit? Like, do you just submit the term sheet or?
So if you require a consent from the regulator, which requires a share purchase agreement to be signed, then you will have to sign it. So
Yeah,
that in transactions where you don't need, most transactions you don't need consent. I mean, you will need consents in situations where you are in a regulated business activity, or your thresholds are higher than what CCI prescribes.
Yes.
So if you don't fall in that category, then you don't need to obtain permissions, and therefore you can do a simultaneously signing and closing process. If permissions are required, and sometimes, I mean, for example, in a business transfer, for example, you have to get consents for transfer of all the licenses and approvals, and there the regulators ask for some documents. So one can even produce MOUs, the initial MOU that you have signed, and say that this is what it is, and we are going to close on a future date. And some regulators will allow you to move forward with that. Some will say complete the transaction and then come. A lot of regulators, specifically in cases of business transfer and slump sales, don't even agree to give you the transfer permission when you sign the document. They want the closing to have taken place, and they say we will give you retrospective after closing. And so it varies depending on what regulatory framework you are working in, what is the nature of business, and that determines the regulatory.
Absolutely. So I hope, guys, it was a good summary for all of you, understanding the life cycle of a deal. So now, if we move to a portion where a lot of people who want to become in-house counsels are interested in knowing about, that if they want to become counsels in companies in future, what is their role when we are dealing with an M&A transaction? When your team is working on a transaction, what is the participation that is expected out of them? What is the assistance that you require out of them? And why I frame this question is, like I said before, that a lot of people are not aware about the level of M&A knowledge they need to become a counsel. And some of them have actually asked me that, is it necessary to work in a M&A law firm before becoming a counsel? So just to shed some light on this particular area.
It is necessary, certainly, I think, to work in a private practice before you become an in-house counsel. And that's not a rule. It's one of the approaches, because when you are in private practice, there is a different kind of rigor and hard work that you put in.
Absolutely.
And when you go as an in-house counsel, that somewhat reduces, and therefore you with that rigor and hard work that you put in, and the hard yard that you've run for some time, I think you've learned a lot more. Uh, Whether you need to know M&A or not, I don't. So it totally depends on which in-house organization you're joining. For example, if you were to join a private equity fund, yes, of course you need to know M&A, because they are going to be acquiring entities all the time. But if you're going to become an in-house counsel in, say, an ITC, which is an operational company in a number of businesses, they're not going to do an acquisition every day. They may sometimes do an acquisition, but then more work that they may be doing is running to court for their tobacco business, or dealing with day-to-day legal issues, employment issues. They may be dealing with IPR related issues, trade remedy related issues. So as an in-house counsel, you are better off as a generalist rather than a specialist. M&A is one thing that you may be doing as an in-house counsel. It's not everything, and you may be doing M&A if you are in an organization that does M&A. If you are with a fund, yes, you will need to do M&A. If you are with an organization that is very fast growing by doing horizontal and vertical integration or by acquiring companies, and you are in that division of their legal team, then you need to be knowing M&A in advance. But in all other situations, M&A is not necessary. You could know other things. If you are going to an oil and gas company, you may need to know what oil and gas regulations are, and not really how do you do an M&A transaction. But as a in-house counsel, I think you need to be more of a generalist, know different aspects of different things, some bit of litigation, some bit of arbitration, some bit of corporate, some bit of advisory, some bit of this and that. Being in private practice before you go can help, because the rigor is a lot more in private practice. You deal with a lot of different situations, you deal with a lot of different clients, and you get a lot more opportunity to learn initially. But even if you were to go directly in-house straight after law school, there's any downside in that as well, because there are certain skill sets of in-house counsels that we as external corporate lawyers don't have, and other lawyers as external legal advisors don't have, which is that ability to deal with the management of the company and with the lawyers at the same time. There's a lot of translation and bridging the gap that needs to be done sometimes, and I think in-house counsels are extremely good at it. They understand, I think, on one hand what their commercial team wants, and on the other hand what the lawyer is saying, and therefore they are able to bridge that gap. So from that perspective, if you were to start with an in-house from the very beginning and grow within within companies in-house, I think that's also a great way of growing. If you were to join private practice elsewhere and then move in-house, that's also a great way of doing it. But not necessarily you need to be doing M&A. I mean, if you're doing a generalist practice, I think that's a better practice to be doing in order to become an in-house at some stage.
Absolutely. And so, like the second part of the question was that while you are undertaking the transaction, what is the participation that you require from counsels?
Yeah. So again, if you are, so let me give you examples. If you are dealing with
by way of an example, it would help.
If you are dealing with an Interglobe is the organization that owns your Indigo airline.
Right.
They have a very large legal team in-house, and they would, in most situations, not even engage external lawyers. They would do their deals and transactions all by themselves. So if
Wow.
you're an in-house counsel in an Indigo, you may be doing an entire deal or transaction by yourself. You may be running litigations by yourself. You may not need to engage so much with external counsels. In some very large deals and transactions, they engage external counsels, and litigations they engage external counsels, and then you get to work with external counsels. And then also they do share a major burden of, I think, doing a lot of things. So if you were in an organization like an Interglobe, which owns Indigo, I think there is a chance that you may be doing everything, and therefore role of a in-house counsel in an Interglobe may be doing everything in an M&A transaction. But if you are in a different organization which has a smaller legal team, say a couple of 1 or 2, 3, 4, 5 lawyers, legal team, the job of the in-house counsel in that situation, or the role of the in-house counsel in that situation in M&A transaction, is mostly limited to bridging that gap. We do the work as external counsels. We'll provide you the draft transaction document or a diligence report. It is your job to review the diligence report and then translate it for your client. When I say for your client, means for in-house counsel, the client is their commercials. Translate it for your commercial team. Explain to them what the implications are. Then come back to us. So their job in that situation mostly is reviewing things that are being done by external counsels and dealing with the commercials. However, and on smaller aspects, minor things, they may still be doing it all by themselves. On bigger deals, they will engage external lawyers, and they will act as sort of a conduit of information and translator for their commercial team, somebody who's bridging that gap. So that will be the job if you are doing a large transaction in an in-house team, which is a small in-house team. If you're a large enough in-house team, I guess you could be doing the entire transaction by yourself.
So, sir, like you mentioned that a lot of times companies come to you when they've already, let's say, they have a term sheet in place or an MOU in place. So, by that means, I think an in-house counsel can also be expected to draft the initial term sheet that is presented to your team.
Yes. So sometimes, depending on whether the client has an in-house counsel or not, it could be drafted by the in-house counsel or just by the commercials. I mean, sometimes term sheets are nothing but just how regular commercial people will write something and they will present it to you. They'll just sign it among themselves and will present it to you. So yes, but in a situation where there is an in-house counsel will be expected to review and provide that term sheet, which can be signed and then can be provided to lawyers. In some situations, in-house counsel, as I said, in smaller deals, may be doing everything by themselves. They may be drafting the SPA and the shareholders agreement, and they may be, of course, interaction and engaging the lawyers is also a big job. If you are in a global sort of a corporation, an Indian company which has very acquisitive outside India, you may not be engaging Indian lawyers. You may be engaging lawyers in, say, Chile, Peru, and you may be engaging with them directly, and then running the transaction sitting here in India as in-house counsels somewhere in, say, Peru, in Colombia. I mean, and you would then be interacting only with overseas lawyers. So it could vary. Your role could vary depending on what kind of organization you are in, and whether it's a large legal team, small legal team, what function you are in. Some large corporates have such a large legal team that they have separate legal team for regulatory, separate legal team for M&A, separate legal team for this. Then you need to choose the legal team. You may end up in a legal team that is probably doing just secretarial work, for example, or some only doing regulatory, providing regulatory assistance, for example. So you need to, depends on which corporate you are with.
Absolutely. So, Asla, I know, I think someone had posed a question that what is a term sheet. So I just wrote it on the chat box that it's an initial memorandum of understanding kind of a thing, which captures the basic intention between two parties who want to enter into a transaction. So, sir, if you would want to explain it.
You could call it a term sheet, you could call it a MOU, memorandum of understanding, you could call it a heads of terms, but it is nothing more than just writing something, the commercial understanding in not so legal terms. You just write down what you've agreed and you sign. You could say that it's a non-binding document only for reference, and that could be a term sheet. It could be a legally binding term sheet, which is like an agreement, enforceable like an agreement, where you agree on high-level terms, and then detailed terms are then distilled out in final transaction document. So it's just an initial document setting out the initial understanding or agreement between the parties.
One of my earlier mentors in my law firm actually explained it in a very funny manner that think of term sheet as something like a ROCA or an engagement, where two parties promise to marry each other, and then the parties, if it's an arranged marriage, they start investigating against both the parties. That becomes the due diligence, and finally, the marriage becomes the transaction document that they sign.
Yeah, I mean,
So,
yeah, but in term sheet there is also something called a break fees sometimes, where
right,
if you don't proceed, then you have to make a payment of the fees to the party who breaks it. So there,
right, okay. So
you,
yeah, that can also be
you
put
can
as a
incorporate
clause.
that principle also. Yeah, absolutely. Not just here, you can apply that clause in ROCAs also.
Yeah, absolutely. In Roka also, ki, if you break it, if there's some fault on your side, we can take you to court or
Damage, yeah,
something like that.
exactly.
So
Exactly.
great. Thank you so much, sir, for actually sharing so much information on the in-house counsel side of things, despite actually being in a law firm. So, sir, a lot of people had this question that now we have a lot of independent advocates who are willing to take up more corporate work. But the notion and the general notion prevailing is that only law firms are eligible to take up M&A transactions for the sheer reason because of the size of it.
Yeah.
But if, let's say, an independent advocate wanted to take up an M&A transaction, is it economically, like, is it viable for them monetarily? Can they actually take up such matters, and like how to identify the right clients? Because the big clients will obviously go to law firms. But what is that space in the market that they can actually target?
See, we are an extremely large country with extremely large number of businesses, extremely large number of opportunities, therefore, for lawyers at different levels. And as you rightly said, if it's a big client going for a big M&A,
Yeah,
an individual practitioner cannot service that client because even if I was to do it within my firm also alone, I can't do it. I need
yeah,
a team. I need multiple lawyers working on a deal depending on what is the size of the transaction and different specialists for different areas of that transaction. You may need tax lawyers for the tax side of things. You may need corporate lawyers for the transaction project management side of things. You may need competition lawyers like yourself to do the
yeah.
CCI filings.
Hmm.
So you will need different sides of, I think, practitioners advising on the same transaction. And those kind of transactions, of course, individual practitioners may not be able to do. What individual practitioners may be able to do is acting one for a smaller size of the clients. There are lots of clients because, of course, as corporate law firms, we tend to be expensive because our costs are expensive, our lawyers are expensive, that entire structure is expensive. And then there are smaller clients who are not in a position to afford large law firms. And for them, I think, on smaller deals where there is a simple, straightforward acquisition, you could help them. There is a piece of corporate law advisory, you could do it for them. So depending on, I think that if it's a smaller client, smaller deal size, smaller transaction, you may be able to find a lot of that work in the market. So there is no dearth of that work. And why I say this is because we keep refusing that work. We can't do it below a certain price. And there is a
Yeah,
lot of work that, we tell our clients that, look, you can't afford us and you will not be able to afford another similar law firm. You may have to go to somebody who will be able to do it for you. And in that situation, you may find corporate lawyers you may find corporate lawyers who outside, I mean, private practitioners who may be doubling their time as corporate lawyers. Ultimately, as lawyers, what do? We determine the rights and obligations of
yeah,
parties, right? And that's the limited scope of lawyer. I mean, whether you're drafting a document, you're doing a dispute, you're determining who's entitled to what. And as long as you can read the law, you can read the company law, you can read the competition law, you can read the tax law, you can advise on corporate transactions as well. Of course, there is some customary knowledge that you need to learn. I guess if you have worked with a corporate law firm in the past, you may have learned it, or if you can learn it from other sources, courses, or
yeah,
whatever. There may be a lot of, there is, like I mentioned, all this deal transaction. What is the trajectory of the deal transaction? What are the terms of M&A documents, etc. Those are not available in your law books, and
right.
those are there. And so those things you will need to learn to in order to advise a client on a corporate transaction, and that advisory can be done by learning it from somewhere. Either you
Yeah,
worked in the past with a corporate law firm, or you find out a corporate lawyer or a person who's been a corporate lawyer who can teach you those things.
right. Absolutely. I think it's also smarter to be on the target side. Let's say usually people who are companies which are acquiring or buying are the ones who actually hire uh, law firms and are in a position to hire law firms. But let's say those who are on the target side, they can approach these not so expensive lawyers to just review the transactions and supervise that whether everything is going fine or not.
That's true, Shweta. The only thing is that, again, target size also depends on who's the target. I mean, there are
Yeah,
very,
yeah,
very
yes.
matured large targets who would hire the best of the firms. Sometimes targets have better lawyers than the acquirers also. So it totally depends on, I think, who the target is. But yes, the smaller startups, for example, startups could be a
Absolutely.
great opportunity where they don't have initial, they've just gone through, so the ones who had multiple rounds of private equity funding, they won't hire private practitioners, but somebody who's just had a seed funding or first tranche of
Yes.
venture capital funding, they may be enabled to hire a lawyer who's not so expensive, and will be able to provide them that basic assistance that is required to a target. For example, assistance with due diligence.
Yeah.
The request will come from the other side for a certain information, and the client's management is not able to collect that information. You will help them collect that information, or reviewing the transaction documents from that comes from the other side. So
Yeah,
those
because
are,
there are
of course,
actually, correctly mentioned, a lot of startups which are at a very seed stage and are getting acquired by tech companies, and they may not be able to afford lawyers. So they
yeah.
just have to follow the investors, or let's say the company. So in that case, they can approach these lawyers, at least these upcoming startups. And
Yeah.
for all those people who want to get into M&A work, I think this could be a good starting point to target
That
all these accelerators which have startups, and you can just get in touch with them.
that and I think there are also these lot of these old styled Indian companies which historically worked only with chartered accountants. If you ask them where did
Right.
they get legal advice from, they got it from a chartered accountant. I mean, they
Yes.
are now becoming matured and understanding that they need to take a legal advice from a lawyer and not from a chartered accountant, and but they are still not ready to pay the fee of a law firm. So that can
They
also
rather
be,
pay the CA.
yeah, they because CAs don't charge, or CA will not
Yeah.
charge enough to them, and therefore they will just take off the cuff advice from a CA and work on that basis. And now they are moving to lawyers, so that could be an opportunity to work with and identify those entities which are requiring legal services but are still not ready to pay law firms. So those could be a good target client base for
Absolutely.
practices.
Absolutely. My father's center itself is an example that they have a CA in place who drafts their rent agreements. And I just did not understand how that worked. But yes, so guys, whoever wants to look for M&A work to start with, I think these are pretty good insights that you can take note of. We're almost done with our session. So since we do have 10-15 minutes in hand, I would just open the podium for everyone to ask their questions. We already have some questions. So, sir, can we just start taking up the questions one by one?
Yeah, sure. So this
So, yeah,
is question and answer box, right?
yes, sir. So I'll collate the
Yeah,
questions for you. We have Karan
right.
who was asking us. I think I can understand law students having the maximum number of questions. That now that we've had COVID coming in, and the dynamics have completely changed for law students for lateral hiring. So if we were to start with law students post COVID, what are the essential qualities that you as a partner and you're in a law firm looking for in a candidate with, let's say, who has 0 to 2 years of experience, who's starting out as a fresher, and also who, let's say, has an experience of 1 or 1.5 years?
So it's a the characteristics vary drastically between a fresher and a 1 or 2 year experience, because if you have even 2 months of experience, then that experience needs to be meaningful. I think if somebody has 6 months of experience, done one transaction, and for us the main characteristic or the main aspect that we are going to check that person on is how well entrenched is that person with that transaction, whether he was actually involved, whether he knows what has been done, whether he was only involved in a superficial capacity, whether he knows what he's talking about. I think, and so that's what is going to be for a experienced lawyer.
Yeah.
And therefore, if you are an experienced lawyer, just make sure that whatever you are doing in the organization that you are, don't let your involvement be of a superficial nature. Try and of course there are limitations. If you're in a bigger firm who may just give you a small piece of work, you may just get a small research assignment, but then just write it like that on your CV. Don't say advised Reliance Industries on investment from Facebook, and
Yeah.
that's all you did. You just researched on something, so just
Yeah,
write.
that's walking into fire.
Exactly, because if you are going to write it like that, then the questions are going to be related to your involvement in it, and the questions are going to be very specific about that deal. And if you've not done it, then your interview will fall flat on its face. If you are a fresher, I think one thing that I've see, of course, as a fresher, if you were to apply for a job in a corporate law firm and you've not done an internship, you have a an uphill task, because most law firms hiring is typically, so there are different types of law firms. So for a firm like us, most hiring is done through fresher hiring is done through internships. People who've interned with us, we try and give as many PPOs as we can, and we do give out a lot of PPOs, and we hire them. Other than that, if freshers were to come to us for this thing, then if they have an impressive CV, they have done reasonable internships, etc., and we interview them. The test that we have in our mind is, we are not going to ask you questions about the deals you've been involved with, but you need to understand contract law. You need to understand the company law. I mean, the most cases, what we find is that while you've come for an interview, you don't know the basics of law. We don't expect you to know anything about what's going on in the business world. We don't expect you to know. You learn it. What we expect you to know is that you understood what you read in your law school. You've understood how contract act works. You know what is a contingent contract. You understand what is a wagering agreement. You understand what are the essentials of a valid contract. These are very basic questions which I can tell you a lot of people who come for interviews don't know the answers to. Things like, against whom can you file a Article 32 writ petition, against whom you can file an Article 226 writ petition. What is the difference between 226 and 32? These are very basic things.
Absolutely.
That all of us learn when we are in law school, but when people come to give interviews, they don't know answers to those questions. So if you have your basics in place and you are a fresher and applying for a job, I think you are sorted. If you don't have your basics in place, then it could be challenging for you to crack interviews in law firms. In post-COVID era, like the pre-COVID era, I don't think much has changed other than the fact that we are working, and like we are doing this webinar online. Other than that, nothing else has changed. For us, as somewhat senior lawyers and partners, it's more challenging because we have to now figure out how to train young lawyers sitting at a distance and build our teams, how to market to new clients and get more work. So it's more challenging for us. But from a young lawyer's perspective, I think the only change is the location of your work, I guess. And this is also during COVID. I'm sure in next couple of months, I don't know, can't be guessing, but hopefully we'll all be back in offices. So we need to, I think, you need to work on. If you're a fresher, then work on your basics. If you're a experienced lawyer, then work on your basics and your CV. Know your CV well. That's the short rule of cracking.
A lot of students have this, and because we are running courses on Lawsikho, they keep telling us we're not from an NLU, we haven't done stellar internships, and we keep focusing on this part that it does not today at least. And because I call myself like a lawyer of this generation, and I was not from an NLU, and I could see that yes, today everything has come down to merit. That yes, your internships obviously carry some weight, but if, like you said, if your basics are not clear, if you're not focusing on the act and some basic things like, okay, what do you mean by damages? What is the difference between damages and penalty? Then no matter, even if you've interned at Amarchand, you will not get a job.
Yeah. So I guess NLUs, exactly. I mean, NLUs, yes, if you are from NLU, it helps you get a campus recruitment drive participation. But other than that, I think it does not make much of a difference. To some firms, some people it may, but to most professional firms, it does not make a difference. It is your knowledge, understanding of law. I mean, if you look at my team, I have 3 lawyers currently in my team. One of them is from that's this RGNUL Patiala. One of them is from Delhi University. One of them is from ILS Pune. I have given 2 pre-placement offers for people who are joining me now. One of them is from again from Delhi University, and one of them is from NLU Jodhpur. So this is the profile of 5 of my lawyers, of whom I guess only one of them is from one of the top NLUs that you consider, I guess, NLU Jodhpur. I am from MIT Law School. So it's I guess a no-brainer. It really doesn't matter whether you are from an NLU or not. In fact, there was this one conference where I was speaking to one of the senior lawyers very senior partner of founders of one of the top firms in India. I won't name that person, but I was speaking to her and it's a lady. So she said that, look, we hire from these NLU or something. So I said, look, you hire from these NLUs, but we hire and you get called for, 40, hiring 40, 50 people from that NLU. We pick up the best 2, 3 people from the other law schools. And it makes a lot of difference. We have far better lawyers than what you would be able to collect by hiring 40 from NLU.
Absolutely.
The difference certainly is there that you have better faculty there. I mean, they'll
Yeah.
teach you, and the more rigorous and a more high pressure environment, and
Yeah.
that automatically makes you a more educated lawyer. And in other law schools, you have to work by yourself.
Yeah.
That's the difference. I mean, if you were to rely on your law school to build your credentials and to build your knowledge, and you are not from one of the top law schools, then I guess it will be tough for you. But if you are doing that by yourself, you are at par with or even better than an NLU graduate.
Absolutely. I think that is absolutely the correct thing, that NLUs give you an environment because you are sitting with the best of the best. They themselves will be racing for the best. That makes you push yourself. In other colleges, you have to push yourself. You may not have that simulation around. So I think that is the only difference that environment provides. Apart from that, I had mentors who were from colleges like Jaipur Law University, and they were senior associates in Amarchand and possessed knowledge like no other.
Yeah.
So, yeah, so this is something I keep dispelling for everyone. And there's a question that a lot of people are asking here also, that what are the textbooks you would recommend for M&A if someone wants to pursue M&A? So how would you want to address the question?
So there are no textbooks for
Yeah.
M&A, to be honest. I mean, you can't read. M&A is not. So when I say M&A, what is it? I mean, when I advise a client on an M&A transaction, I read the company law, I read the tax laws,
Yeah.
I read the stamp duty acts, I read the, depending on the nature of transaction, I may be reading, if it's a capital market related, I may be reading the SEBI and SEBI regulations. I will read the FDI policy. I will read FEMA. I will read, depending on, again, if it's an insurance industry transaction, I will be reading the Insurance Act and the insurance regulations and the other circulars and notifications issued by the department. So it is nothing but reading a different large set of laws. It's not, M&A is no one law practice. It is a practice which involves reviewing multiple laws. If you want to understand how M&A works, I think that you can find material. I mean, you may be able to find material online. You may be able to find courses that can teach you what an M&A transaction is. But more of it and most of it you will learn when you actually join a practice and you start doing it, because it's not something that you can just read somewhere and understand. It's
Absolutely.
practical understanding of things that you will only get when you start doing it. To get there, you need to have your basics in place. Have your basics in place. M&A, let M&A come to you when you practice. Don't worry about learning that.
Absolutely, guys. For any law whatsoever, yes, textbooks are a good guiding point, but everything comes down to you having to read the act. There is no other way around it. There's no shortcut to it. You have to read the act from the very preamble and then take your route from there, and then probably refer to books to understand the section better. But the reverse is something that has put me in trouble, where if I read the commentary first and then come to the act. So I would rather like say that yes, go through the act, like Sir said, that Open Companies Act, open. Fortunately, we have acts which themselves are textbooks. So just go through them, and then I think for those people who want to develop an aptitude, please keep a track of all the deals that are happening on a regular basis. What like Bar and Bench keeps posting deals. Start reading those deals. See which firms are involved in it, and then you'll also get a better idea that okay, what are the firms that are involving themselves in M&A transactions. So I think that would be a pretty good way to go about it. Then let me just take up these hiring related questions together, and then we can take up the technical questions after that, because we do have some technical questions. Let me just see if I've covered all the. So Asla, I think I've covered that question where you said that is having a commercial awareness and advantage to the practice in corporate law. So I think that is the biggest advantage that you would have, that you should be aware of what are the basic transactions and deals that are going on right now. Then what is the minimum and maximum period of a deal in M&A?
There's no answer to it. It can
Yeah.
be 5 days. It can be 5 years. So
Absolutely.
it totally depends on what you're doing. I think there are deals that the clients come riding on a horseback and you have to complete a transaction in a week. We've done a transaction where we acquired 7 companies, completed diligence, transaction document signing and closing in 7 days. And
Yes.
then there was a transaction that we've been doing, I think, for last 3 years, which has not completed yet. It's just one investment in one company. So there is no time limit for it. It's totally depends on deal commercials and how parties are approaching.
Absolutely. There's a technical question by Asla over here that, Asla, please let me know if I've understood it correctly. That does India have a special purpose acquisition company deal for acquisition? Is it valid in India? Uh, is he's calling it a special purpose acquisition company deal for acquisition?
So I don't know whether you mean special purpose vehicles, but of course there are special purpose vehicles. Special purpose vehicle
Yeah.
means nothing but a company which has been incorporated for a special purpose. I mean, you've incorporated a company for doing a specific business. That's a special purpose vehicle. You may get a contract from the government. You want to execute it. To execute that, you incorporated a new company. That is a special purpose vehicle in which you will do nothing else. You've incorporated a company to acquire another company. That's also a special purpose vehicle specifically for acquisition of another company. If you were to make an investment into a special purpose vehicle, which is only a foreign investment into that, which is only going to invest further, that's not permitted. That requires an FIPB approval. Because it's considered an investment company. From a foreign investment perspective, there is a difference between whether or not you can invest in it. So from an Indian law perspective, foreign investment and only an entity which is only an investing entity. If it is a special purpose vehicle for operating a business, then it's fine. But if it's a special purpose vehicle only for investing into another entity, then there are foreign exchange restrictions on foreign investment. Otherwise, any company that you incorporate only for a special purpose is a special purpose vehicle.
Yeah, Asla, I think, yeah, if you were looking for a question on SPV, I think that, yeah, that is the answer. We'll circle back in case you have any doubts. Pranit is asking that, could you please put some highlights on a path from an M&A lawyer to becoming an investment banker?
Yeah. No, so I guess of course, it is a path a lot of people take. If you are a M&A lawyer, and specifically if you are an M&A lawyer advising clients on private equity funds, if you are advising on private equity deals, venture capital deals, or if you are advising investment banks, it may be an easier path because you may have contact. But I guess the path is simple. You have to the easiest and the most common path is leave law, do an MBA, and become an investment banker.
Yeah.
The other path to do it is if you can find an investment bank that is looking to hire lawyers, which is not frequent, but if they have a close relationship with you, they think that you can be of help, and you can join them as a legal advisor and slowly move into the commercial side of things. That's another way of doing it. And similarly, if you want to become a private equity investor or a venture capital investor, it's the same way. I mean, you either go do an MBA and then join an investment bank, or join a private equity fund or a venture capital fund, or if you can find a job there as a lawyer, then slowly move and transition yourself towards the commercial side of it.
Absolutely. So, Pranit, I hope that has helped answer your question. So, Asla is asking that, do M&A lawyers also take part in the auditing process? That can lawyers
So when you
audit
say
the company in M&A transactions?
I don't know, when you say audit, so the audit is, if you are talking about the accounting audit, we have no role.
Yeah.
Because audit typically, as colloquially, it is used for accounting audits. But if you're talking about, there is also a legal, what we call due diligence. You can also call it a legal audit. So audit is nothing but inspecting the records and confirming existence of certain facts. That's what an audit is. And if you could be doing a legal audit, you could be doing accounting audit. Legal audit, of course, we do. Accounting, financial audit, we have no role.
Because that is actually quite a confusion, especially if lawyers are wanting to do some sort of take part in the legal due diligence, where to draw a line between a financial diligence and a legal due diligence, because there might be some overlaps there, if I'm not wrong.
So I guess, line is actually for financial and legal is there may be some overlaps, but it's not so blurred. I think one knows that there are certain things that a lawyer, for example, a director's report, a lawyer will also read and a financial auditor will also read while doing a due diligence. Lawyer is looking for different things, non-compliance with law. An auditor is looking for different things, non-compliance with accounting standards, liabilities, those kind of things the accountant is searching for. So you may be reviewing the same documents, but what you are trying to reach at, those are two different goals. So there is no, as such, there is no, conflict between an accountant and a lawyer when it comes to doing due diligence. And there is a third aspect of it, which is tax. So you put it in three buckets: accounting, tax, and legal. And within legal also there could be many others, environmental, etc. But just keeping legal all together, uh, I guess there would be some overlaps between in the documents you will review, but the ultimate findings you are looking for are very different for an accountant and very different for a lawyer.
Absolutely, sir. So, Divija has a question here. It's a bit of a technical question, I think. That, sir, can you shed some light on break fees and reverse break fees? Do you personally include such clauses while entering into transactions?
So it's not, so in India, it's not very common. The reason is that, term sheets in India typically are executed with I mean, as mostly non-binding. Sometimes even if they are binding, people don't want to put in fees or reverse break fee concept because parties believe that both parties would be incurring an expenditure in running the show until the deal falls apart. But in certain transactions where, for example, if you are representing a fund, and the fund doesn't want the investee company to back out because fund is going to make huge investments in not just doing the transaction document but also doing diligence, etc. Then they put a concept of a break fee, and you would see break fee in those kind of transactions where if the deal falls, then the investee company or the promoters of the investee company have to make a payment of a break fee to the fund which had signed the deed and has incurred expenditure. But it's not very common in India. You do find it in various transactions, but not very common. Internationally, I understand it's a lot more common.
So, if you could actually just, for everybody else's knowledge, explain what break free and reverse break free concept is, so
So
everybody
break
could just
fee, reverse
understand.
break fee is nothing but if you are coming to me and telling me that you're going to acquire my company. So if I am the investee company, if you're telling me you're going to acquire my company, and the transaction falls apart, then I make you a payment, or the investor makes me a payment, depending on what side is going to incur more liability, is a break fee or a reverse break fee. There is no uh, rocket science to it. It's just a penalty for not following through your promise of letting me do the diligence and complete the transaction or what you originally promised.
Absolutely. So, Divya, I hope that answered your question. So yeah, they're not allowed to unmute themselves, so I'll take that as a yes. So okay, yeah, she said thank you, sir. So guys, we're almost ending our session right now. If you have any other questions, I would have loved to entertain them live, but we are kind of on a time constraint because another webinar is about to start in 10-15 minutes. So I'll request all of you to email your questions to me at shweta@lawsikho.com. Lawsikho.in, sorry, and I will forward the questions to Sir so we can get them answered. So, Sir, thank you so much for sparing the time on a weekday and coming for this quick session, which was actually quite helpful because we discussed so many things in this short span of time. And once again, thank you so much for coming and enlightening us on this particular topic. It was actually quite helpful for everyone.
No problem at all. Thanks a
And
lot,
thanks
Shweta.
so much, guys, for taking out the time to come and attend the session. So we'll see you all for the next webinar if you registered for it. And thanks for hoping to have you around more often.
Thanks, Shweta. Nice talking to you, and thanks everyone for attending.
Absolutely, sir. It was a pleasure. So thanks.